Nelson Havi, who is also an advocate. Good evening, and thank you for creating time to be here.
Good evening. Welcome.
Oh, of course, welcome. So let's start with it, because a lot of Kenyans need a country that is moving in as far as the Constitution is concerned. Less play and more action. And now here it is. There's a bit of a dilemma following last week's events into the weekend. Here's the big question. Who is the deputy president? Rigathi Gachagua? Kithure Kindiki? Who is it, Gachagua or Kindiki?
In the court of public opinion, Kenya is a tale of two deputy presidents.
Public opinion?
Public opinion.
Okay.
That is Rigathi Gachagua, who enjoys a court order staying his impeachment, and also who enjoys a court order suspending the assumption into office of Kindiki Kithure. But the reality of the matter in law is this. Rigathi Gachagua ceased being deputy president upon the passing of the vote by the Senate. So he's no longer the deputy president. Is Kindiki Kithure the deputy president? No, he's not the deputy president. The deputy president assumes office upon taking oath. So to answer that question with precision, we do not have a deputy president in Kenya right now. And that portends a fundamental crisis.
So you're saying in clarity that at this point in time, as we're speaking tonight, we do not have anybody in the position of a deputy president in the country?
No, we don't have a deputy president.
Let me take you back a little bit when you started with the public opinion, remarks, and said deputy president enjoys certain court orders.
Yes. The deputy
Why would he enjoy them if he still doesn't remain as deputy president?
You see, a court order is valid until otherwise set aside. We have two orders. One order has suspended the decision of the Senate impeaching Rigathi Gachagua as deputy president.
All right.
Another order has prohibited the assumption into office by Professor Kindiki Kithure as deputy president upon nomination and confirmation by the National Assembly. So that is the legal conclusion that can be drawn from this scenario.
All right, because the question then is, because we had this interrogation as well, the same day we saw this stay order that spoke about the impeachment by the Senate at that level, but there are conversations about it saying it has been overtaken by events based on the timeline on which it was, it surfaced and when it takes effect. And let's also look at the one that has come then that blocks the swearing in of Interior Cabinet Secretary Kithure Kindiki. When it comes to the timeline of each of these orders, is there any of them that has been overtaken by events as you also bring them into the conversation tonight?
Now, the question as to whether or not these orders have been overtaken by events is one for the court to determine.
All right.
A majority of us lawyers have delved into that argument and reached the conclusion that the orders have been overtaken by events. It's erroneous for any lawyer to take that position because there is a court order. A court order will last until otherwise set aside. And it's not long until such a time as the court will have the opportunity of giving a finality to this matter.
Here we go now. The question is coming in as far as the constitution of the three-judge bench is concerned. A lot is expected to happen tomorrow within the courts. In fact, we're looking at the numbers of petitions rising from 20s to now about 35, even as reported by a reporter. And the question is now, what are we expecting tomorrow in the courts? What are they really going to be looking at, even as the deputy president, once again, has changed tune a bit? Earlier on, he had his reservations about the Senate, and now him and his legal team has reservations in as far as this three-judge bench is concerned. What are we looking at tomorrow in the courts, Wakili?
Well, the Constitution prescribes that everybody has the right to have a dispute concerning him or herself determined by an impartial court or tribunal. Now, Rigathi Gachagua has submitted his dispute to the High Court. Now, if he has any concerns as to the partiality of all or any of those judges, or any other petitioner has partiality to any or all of those judges, then what has to be done is for an application to be made to that court to indicate the facts that confirm the fear of bias, whereupon the court will consider the matter and make a decision. It's not an issue that is to be addressed by correspondence from a party or a party's advocate to the Chief Justice or to the Deputy Registrar or to any of the judges. That is improper. A formal application has to be made before the court. It must be demonstrated that there is bias for it to be entertained and allowed.
So you're saying this approach by writing the letter to the registrar, was it really prudent?
It is inappropriate.
Inappropriate, your words, Wakili.
Yes.
Very interesting. So then if it was inappropriate, then how are we expecting the courts to behave? Because he's actually bringing in the Chief Justice, Martha Koome, at this point in time, because she constituted this three-judge bench, if I follow earlier on, at his own request by his legal team then. Now, what happens? Will the courts then take into consideration what you're terming as inappropriate tomorrow, or will they proceed?
The court is not a post office.
Okay.
The court must be moved. You do not address letters requiring the court to consider your complaint of bias by way of letters. If there is no formal application before the judges tomorrow, then the courts will proceed as if there's no challenge on their constitution.
Is there a timeline for his legal team to act in as far as the application is concerned and not through a letter to the registrar?
Of course, it has to be done expeditiously because what has been set down for hearing tomorrow is the inter partes hearing of the two applications. One by the Deputy President former, and the other one by third party who moved the court on behalf of the former Deputy President.
All right, now let me just look at this, and there's a concern here of there's a case to be heard on October 24th.
Yes.
There's another on the 22nd of October.
Yes.
That is tomorrow.
Yes.
In this whole, corridor of justice events, the question is now, I mean, the whole procedure in court will lead us then to knowing if Kithure Kindiki will be sworn in, and in what period of time, because the president is given 14 days within the Constitution.
Yeah.
In what timeline, or what is the timeline for the courts then to look at all these issues before them, conclude, and allow the president to have a new working deputy president?
This is an unprecedented scenario because the Constitution does not provide for an avenue for the court to intervene in a case concerning the impeachment of the president. And the impeachment of the deputy president is tailored upon the same fabric as the impeachment of the president. And you may therefore ask this question.
Yes.
Assuming that it was the president who had been impeached, will he have moved to court? It is doubtful the president will have moved to court. But nonetheless, the former deputy president has moved to court. It is his right to move to court.
Okay.
The question is whether the High Court has jurisdiction to entertain his claim and allow his relief. The starting point is he stands dismissed, effective the day that the vote was passed. So ideally, what he will be doing in court is to ask for reinstatement. Is that capable? An order for reinstatement is incapable because it can only be available in a case of an employer-employee relationship under the Employment Act. It does not appear to be a remedy that is available in these circumstances. Then there is need for us to dichotomize the powers of Parliament and the powers of the court. Parliament has absolute power and jurisdiction to determine the removal of the deputy president or the president. No doubt whatsoever. The High Court, on the other hand, has the power to consider whether there has been a violation of rights and freedoms under the Bill of Rights. It follows, therefore, if the former deputy president has submitted his case to the court, then it is incumbent upon him to demonstrate that Parliament did not follow the correct procedure in arriving at this decision. Because irrespective of whether or not Parliament followed the correct procedure, if Parliament is permitted by the Constitution to arrive at the judgment removing the deputy president, then that decision cannot be faulted. And so far, it has not been demonstrated, at least from a prima facie perspective, that the former deputy president was not accorded the constitutional parameters upon which to present his case. He presented his response. His lawyers were able to cross-examine all the witnesses. The only failing was that he was not able to attend in person. But is that a failing that negates the hearing? It is doubtful, because the former deputy president has been heard twice. He gave a press statement where he read all his response verbatim.
Yeah.
He appeared before the National Assembly where he read his response verbatim.
For 2 hours.
For 2 hours. Nothing will have changed before the Senate. But fundamentally, a hearing before the Senate does not necessarily entail the former deputy president being heard by his own mouth. Because compare this. Before the Supreme Court, when you were challenging the election of the president, none of the parties appear to be accorded an oral hearing. Their arguments are taken on the basis of the affidavits and the legal submissions made by the advocates. So to that extent, the procedure and the merit was duly followed. Yes.
All right, now we'll be following closely your feedback even as you continue this conversation. But Wakili, even as you said, nothing would have been different before the Senate. 2 hours in the National Assembly, 5 hours in the Senate, where we're expecting a bit of cross-examination as well. Might have made a difference, Wakili? Though I will come back with that. And there's also a word going round in, respect of public interest. Yeah. This word public interest, what does it refer to? And are we confusing it maybe at the layman's level with public participation? We'll clarify that among other things, and also with your feedback right after this break.